So today we're going to transition into our last real complete section, which is privacy. And this is one of the harder sections for this class, in large part because the right to privacy sort of plays itself out and battles through the court in the means of sexually based privacy, which we'll see very clearly in the first case that we do. So the privacy rights in the United States are tied almost intrinsically with the notion of sexually based privacy, but that really doesn't have to be the case. Largely because privacy is much broader than that. And we know that there exists no enumerated right to privacy within the Constitution. And privacy, much more broadly, is a huge area, and that we'll only be discussing a small portion of it, a portion of it where privacy comes into existence, the notions of a right to privacy comes into existence, and that is focused on sexually based privacy or reproductive privacy. But privacy concerns, especially privacy with regards to protections against the government, protections of governments in general, are exceedingly broad. So the example I have here is like, can the government sell the information that you list publicly in your driver's license? Other examples, can police track you via GPS? All of these things sort of blend into privacy-based questions. But since we're going to focus on where privacy comes from, where the notion of privacy in the United States, the legal right to privacy comes from, so we're going to focus almost exclusively on notions of sexually based privacy or reproductive privacy. So before we talk about privacy, and we recognize that it exists nowhere truly within the Constitution specifically, we also need to remember Alexander Hamilton's warning regarding the notion of the Bill of Rights. And remember that Hamilton was very strongly against the Bill of Rights. And the reason for that was he thought that at some point in the future, some individuals hearkening back to something akin to a founding of the nation would look to the Bill of Rights and say that those were the only rights that the individuals who drafted the Constitution intended the people to have. And he was worried about that because there existed other residual rights that obviously weren't going to be included in the Bill of Rights. Part of his critique is ultimately what leads to the Ninth Amendment, which simply states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, which is to say the Ninth Amendment is sort of a catch-all in which you can put other rights that may exist into the Constitution. So there are examples of privacy, things that touch on privacy throughout the Bill of Rights, nothing that explicitly, however, announces a doctrine of a right to privacy. When the First Amendment, we have freedom of speech, we also have freedom of thought and freedom of association, and all of these things sort of blend into at least a question of privacy. Through the Third and the Fourth Amendment, we can see elements of privacy in terms of being secure in our own homes. In the Fifth Amendment, we see a protection against self-incrimination. We also have notions of due process rights. And all of these sort of add up to different aspects of privacy. And the reason why I include the 14th Amendment here is not because there's anything specific within the 14th Amendment that seems to give rise to a right to privacy, but this is the method by which the courts apply rights to the states. And so once we get to Loving v. Virginia, which really spells out this idea of a right to privacy in very explicit terms, you'll see how the Fifth Amendment sort of plays a role in regard to that. Now, privacy concerns from the founding until really the early 1920s weren't really addressed by the U.S. Supreme Court. And it really isn't until 1927 that we get a discussion of the notions of privacy without sort of articulating any form of protection. And the case in which this happens is Buck v. Bell. Now, Buck v. Bell is one of those notorious cases in which the Supreme Court gives itself a black eye. And this is a case where the opinion is drafted by Justice Oliver Wendell Holmes, who is a very, very respected jurist. And in this case, we see sort of elements of him being a product of his times. And he uses, throughout the opinions, faulty science based on the notion of eugenics, which is, I mean, the foundation for a number of atrocities that have played out, throughout the world, and they're pretty much embodied in this opinion. So let's delve into what the background of this case is. This is the first major case concerning privacy, and it dealt with the concept of forced sterilization. And the sterilization was forced upon those who were seen as mentally unfit. There were a few early cases in lower court which struck down as unconstitutional laws that dealt with sterilization, usually regarding prisoners. But they never reached their way to the United States Supreme Court. And so that precedent which prohibited sterilization never reached a nationally based precedent. So the law at issue here is significantly broader than just prisoners. So in particular, coming from Virginia, they had a law which provided for sterilization of inmates in state institutions that had what was considered a hereditary form of insanity, idiocy, imbecility, epilepsy, and crime. So all of those things were thought to be hereditarily handed down, and as such, the state argued that ending these family lineages was one way in which to stop this hereditary transfer of these things. In this case, concerns Carrie Bell. Carrie Bell, this is directly from the case. Carrie Bell is a feeble-minded white woman who was committed to the state colony for epileptics and feeble-minded in due form. She is the daughter of a feeble-minded mother in the same institution and the mother of another illegitimate feeble-minded child. We're going to come back to it, but it turns out that Carrie Buck's child was in no way or form defective mentally, nor really was Buck nor her mother, but that's some sort of history we'll get back to. Anyways, the state and the institution believed that carrying out these forced sterilizations were in the best interest of the individual and also of society as well. They argue, the state, that there can be no doubt that so far as procedure is considered, the rights of the patient are most carefully considered, and at every step in this case was taken in scrupulous compliance with the statute, and after months of observation, there is no doubt in that respect of the plaintiff that she has had due process of the law. The opinion of this case never deals with, specifically in tone, the right to privacy, though they dance around it pretty specifically. Justice Holmes really uses some language in this case that sounds very similar to the cases involving female attorneys in the late 1880s. So Holmes says that it's better for all the world if, instead of waiting to execute degenerate offspring for crime or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. 3 generations of imbeciles are enough. That line about 3 generations of imbeciles are enough is probably one of the most famous lines ever written by the court. And it's odd that it comes from Justice Holmes, who was considered exceedingly progressive, far ahead of his time in terms of protecting individual level rights, but absolutely not in this case. So this case deals with a due process question. So the issue in this case is whether forced sterilization as conducted in the state of Virginia is a violation of an individual's due process rights. And the court unanimously says that no, that is not. And the reason for this is based almost entirely in the notion of eugenics and in terms of hereditary nature of crime. So this decision legalizes this forced sterilization, and this forced sterilization, as we know, was problematic even for the individuals who underwent it, primarily because a large number of people, years after this case was handed down, it was realized that none of them realized that they had been actually sterilized. One married couple in particular were asked, how does it feel to have been subjected to this procedure? And the woman's response upon this interview was, now we know why we've never been able to have any children, because we've tried all these years and I never could figure out why I couldn't get pregnant. In the case specifically of Carrie Buck, the state introduced false evidence as one of the reasons why she should be sterilized. They said that she couldn't control her sexual impulses, and the birth of her illegitimate child was proof of that, without ever taking into account the fact that the illegitimate child was fathered after she was raped by her cousin. So it had actually nothing to do with Carrie Bell's mental intellect, whether it was high or low, but she was a victim of a sexually based predatory crime. And that certainly did not lend any credence to the notion about why the state argued that she was ultimately sterilized. As for the claim of that her mother was a mentally deficient state, as was she, as was her daughter, who ultimately did die at the age of 8 due to an intestinal disease, made honor roll in school every year that she was there. She had no problems while she was in school. And it turns out after this case, both Carrie and her mother were entirely functional members of society after this case ended. Now, to look at the particularized example, looking at the institute in which this took place, it was simply known as the Colony. At the height of their eugenics-based program, they performed around 20 sterilizations a day. And in the totality of as the program was run, it sterilized over 8,000 men and women, the vast majority of which didn't know about it. Carrie Buck's sister, for example, did not know she was sterilized until years later. They also sterilized numerous children who were orphans. Many of these children were sterilized in their early teenage years, some as young as 15. And so we know this case takes place in 1927, and it might give you some, it might make you feel a little better to think that this is such an antiquated thing. This is almost 100 years ago. Well, it turns out that the state in question, Virginia, kept the program going all the way until 1972. So there was an overwhelming amount of time that this case took place. And we shouldn't just blame Virginia in this regard. In fact, as best as we can estimate from documents, around 72,000 people were subjected to compulsory sterilization in the United States, largely in part pushed by the eugenics type programs and the argument that that Justice Holmes makes in this case. The procedural protections simply didn't exist. And in Buck v. Bell, which ultimately legalizes this form of eugenics-based science, while there is discussion of privacy rights here, one thing that I really want to end on is that this case, Buck v. Bell, has never been explicitly overruled by the United States Supreme Court. And so, like, technically, this case still is good law in the United States. So this case sort of sets the stage for where we go in terms of privacy, understanding that our starting point of the most intimate notion of sexual-based privacy, the choice of whether to have a child or not, was taken away from a large number of individuals based on faulty science, based on evidence that simply wasn't true, and based upon this assumption that there existed some form of hereditary notion of any sort of mental diseases which the state could simply accuse an individual of seemingly at a whim.